Appeal is dismissed.
May it please, Lordship. Lordship, in respect of item number 4, we had filed an IA, but that has not been listed. If it can be called for, I have got a requisition slip. Item number 4.
IA for what?
For bail on health grounds, because the person has suffered, appellant number 1 has suffered a cardiac arrest.
Why, when it is filed?
My lord, on Monday, 24th.
Huh?
Obliged.
May I please, your Lordship? Lordship, one criminal revision petition number 553 of 2023, Lordship, is pending disposal before your Lordship. Lordship, so far the last order is concerned, that is 23/4/2024. According to this order, Lordship, the case was supposed to be listed after 1 week, Lordship. Service was complete, Lordship. On the last occasion, Lordship, the case was listed in the stage of admission, Lordship. Therefore,
Before the division bench?
no, Lordship.
Then why you are mentioning? You don't know the procedure?
Sorry, Lordship.
Sorry, counsel.
It is for admission item number 2.
Lordship, kindly pass over for time being. Senior is on legs.
Supplementary list item number 21.
May I please, your Lordship? This is an statutory appeal, Lordship, where the appellant convicted under section 302, Lordship, and 34 IPC, Lordship, for
Heard Mr.
Ayush.
Ayush Chaudhary, learned counsel for the accused appellants, and Mr. K.K. Das, learned additional public prosecutor for the respondent number 1, state of Assam. Full stop. This criminal appeal under section 374 within bracket 2, Code of Criminal Procedure 1973 is directed against a judgment and judgment dated 5/6/2024 and an order on sentence dated 7/6/2024 passed by the learned additional sessions judge within bracket FTC North Salma Obhayapuri in sessions case number 22 within bracket A of 2016 stop by the judgment and order on sentence, the accused appellants have been convicted for the offense under section 302, Indian Penal Code Reduit 34, IPC. And they have been sentenced to undergo rigorous imprisonment for life each and to pay a fine of rupees 50,000 each, in default of payment of fine, to undergo simple imprisonment for another 3 months each. Stop. The appeal is admitted for hearing. The case records of sessions, case number 22, within bracket A, 2016, be called for, issue notice to the respondents. The notice is made returnable in 4 weeks. As Mr. Das, learned additional public prosecutor, has appeared and accepted notice on behalf of the respondent number 1, state of Assam, issuance of formal notice to the respondent number 1 is dispensed with. However, extra copy. The accused appellants shall take stage for service of notice upon the respondent number 2 by registered post PTAT as well as by usual process within 3 working days.
Lordship, as per notification dated 15/3, Lordship, in 302 cases, Lordship, notice is not required, Lordship.
You have made party,
Lordship,
so you have issued notice.
Lordship. I is there, Lordship.
Okay, applicant appellant लिखो भाई उन्होंने इतनी बाकी नहीं हाँ
How
Aye.
was it?
For order, item number 3. Kindly pass it over for time being, Lord.
timing
Because it is looked after by B, it is looked after by.
Hmm.
Item 5.
5 is also.
timing
Item number 6.
Receive report.
yes applicant is stable, he has undergone surgery, stable.
Lordship. Can you kindly take it after some time, Lordship? Mr. ARV is on lag, Lordship. Kindly. Applies, Lordship.
Item 7.
Lordship, the convict is, appellant is under custody for almost 9 years, 9 months. It's unfortunate case because the appeal has also only been filed in 23, Lordship.
Hmm.
So considering that length of detention, Lordship. Otherwise,
Length of detention is not a ground.
the evidence is also, Lordship, not very clinching, Lordship. May I read, Lordship, some of the,
What is this IA first? 1200?
one is there is correction of the name. It should be Ranglal. It is written RAGLAL.
Where?
While filing the appeal, Lordship.
In
In the
the
cost
appeal
title,
memo?
in the cost title of the appeal, that's my fault, Lordship.
Rogla.
Our fault, Lordship.
I need to prosecute you for your. Heard Mr. B. Chakraborty. Learned counsel for the applicant appellant. And Mr. K.K. Das, learned additional public prosecutor for the opposite party number 1, State of Assam. First of the instant interlocutory application is preferred. Seeking correction of the typographical stroke clerical error, which has crept in the cost title of the accompanying criminal appeal, criminal appeal number 399/2023. Full stop. Where it is averred that because of typographical clerical error, the name of the applicant as the appellant in the accompanying appeal has been typed as paragraph 2, quote unquote, Roglal, Raglal, whom is unquote, instead of quote, Ronglal, whom is unquote, in the cause title of the accompanying criminal appeal. Full stop. It is submitted by the learned counsel for the applicant that the said typographical error, stroke clerical error has been kept in inadvertently. Full stop. Where in regard to the nature of error, stroke mistake, it appears that the same is a typographical stroke clerical error, which is crept in inadvertently. Full stop. In such view of the matter, the instant interlocutory application is allowed. Full stop. The office to correct the name of the applicant in the accompanying appeal in a cause title of the accompanying criminal appeal, criminal appeal number 399/2023 as Ronglal, Ranglal, whom is quote unquote, instead of Roglal, whom is full stop. Necessary corrections are also to be made, in a CIS. Yes,
Lordship, so far as the Lordship PW one was the informant law. She's,
have you filed? Have you
We did.
filed your objection?
no, that's not,
Ah.
not filed. Long back Lordship it was filed.
Yes, why don't you file?
And
IA 2 weeks time. That was in December. MS Bora heard Mr. B. Chakraborty, learned counsel for the applicant appellant, and MS Sage Bora. You took time.
Lordship. Can it be
Learned
addressed?
additional public prosecutor for the opposite party number 1 state of Assam. Full stop. MS Bora, learned additional public prosecutor has sought for and is granted further to extend.
Lordship.
To file an objection.
File after vacation, Lordship, fix a date.
To file an objection to the instant application under section 389 CIB. Place the case immediately after the ensuing summer vacation on a date to be fixed by the
File the
office.
objection.
Item 8 and 9.
8 and 9.
May I please, your Lordship. Lordship, in this case, Lordship, notice was issued, Lordship. Notice was issued, Lordship, and they filed their Ukalataba, Lordship, as per number 2.
This is
Yes.
offense is 302
302.
149.
Lordship.
Yes.
And
Who is
it-
entered appearance? Okay. Respond number 2.
Response number 2. Their name may be shown in the cause list.
Paperwork ready?
Not yet ready.
Paperwork not ready. Yes, what is your
Lordship, IA is there, Lordship, in item number 9, Lordship. They have filed their objection, but in item number 8, we have not received objection,
Oh.
Lordship.
yes, Ramesh Bhaiya.
File Lordship.
Heard Mr. Ayu Chaudhary. Item number 8 will give you. IA2 27 IA 27,
27, 24.
2024.
It took for
Is it so? No.
Eight.
it took on
Which
all
one?
goods.
Item number 8,
Eight, Lordship.
27, huh? IA 27, 24, huh?
The appellant represents
While Mr. I. Chowdhury, learned counsel for the applicants, appellants, and MS S.H. Bora, learned additional public prosecutor for the respondent opposite party number 1, State of Assam. Full stop. MS Bora, learned additional public prosecutor, has sought for and is granted further 2 weeks' time to file an objection to the interlocutory application filed under section 389 CRPC. Release the case after 2 weeks, along with criminal appeal number 5/2024. Immediately after the ensuing summer vacation and read to be placed by the office.
Highly ordered.
Okay.
Mr. WSA, what are response number 2? Learned. I can't have a he got objection, I got
All right.
Item 10.
Here, the objection has not been filed manually
who?
We have.
by the
read-
private.
State file, status file.
State has filed.
Yes, MS Board.
This has not prepared, informant has come, already I have filed a written objection, my lord. I think 6 on my, just now he has come, but
Okay.
today sometime, already I have filed a written objection.
Yes, when you want. And it will go after vacation.
Vacation.
Naturally. Heard Mr. P.K. Monir, learned counsel for the applicant appellant, MS S.H. Vora, learned additional public prosecutor for the respondent number, opposite party number 1, state, and MS P.V. Bordole, learned legal aid counsel for the opposite party number 2, stop. MS Bordole, learned legal aid counsel for the respondent number 2, has submitted that the objection to the instant interlocutory application under section 389 CRPC is going to be filed during the course of the day. By serving, you have received
No,
by serving a copy to the learned counsel for the applicant. Full stop. Such view of the matter, let the case be listed immediately after the ensuing summer application and date to be fixed by the office with the objection of respondent number 2 on record.
Item number 11.
Lordship, in the last.
it also asks me to
Be हुई है
time being low.
Item 12.
In the earlier occasion, Lordship, notice was sent to respondent number 2 as the usual process through AD card, Lordship. So I think Lordship mandate of.
Report.
Yes.
This is what
Press-
FOXO,
yes, Press steps has to be taken by the respondent.
because we are examining whether it is trial is vitiated or not,
Lordship, lordship,
right? That is why.
lordship. Report was called for last occasion.
Marble.
No detail.
बुद्धिमानी नहीं की ना। बुद्धिमानी नहीं की ना। Oh,
So intimation was done to the district and session judge. That's
hmm. Hmm. এইটোৰ পৰা ওলাব মানে বিলৰ পৰা বিল কৰিছে ইমান ভেৰিফাই হ'ব ওলাব এতিয়া because trial court has not recorded during the on the dates when evidence was recorded, whether PP was there or not there.
lordship.
But here they said he remained absent throughout the trial, but still they are requiring the bills, etc. Whether
It's
that
whether.
Daniel Das
was
has raised bill
there at
for
that
attending the
relevant
trial or not.
Yes, lordship. So time,
We can wait for a report.
lordship.
Mr. Chaudhary,
Lordship,
the judicial department is writing to the district and session judge Sirang
Lordship,
to obtain further information,
Lordship,
whether the public prosecutor has whether attended
Lordship,
the trial or not, and whether he raised bill
Lordship. Then Lordship may fix immediately after vacation.
after vacation.
Date may be fixed.
I heard Mr. Ayub Chaudhary, learned counsel for the accused applicant, and MSSH Bora learned additional public prosecutor for a respondent state. Full stop. MS Bora learned additional public prosecutor in deference to earlier order dated 12/6/2024, comma has placed a communication bearing number so and so, dated so and so, written of the secretary to the government of Assam Judicial Department, comma addressed to the district and session judge, comma Sirang, whereby relevant informations, documents, certain relevant information, stroke documents are called for. Full stop. MS Bora has thus submitted that the ESB posted immediately after the ensuing summer vacation to enable her to obtain further report in this regard. Full stop. List the case.
On 19th or 22, lordship.
22.
Lordship, I don't.
Obliged.
The communication bearing number so and so is to be kept with the case records.
Obliged.
Item number 14.
May I please your lordship? Lordship, senior counsel Mr. Jetkamar on his legs, kindly pass over the matter for time being. Bless lordship.
Item 15.
There is a delay of 339, the petition accused is in jail since 22/9/2022. So there is a good ground in the bill and the limitation, the wife and only the minor that are in the family. So for that regard, because 20 years imprisonment was given under section 6 and 10.
Service,
That has been done. That is complete.
service,
That is complete.
Lordship.
POXO.
I have otherwise, my lord, prepared a list of dates, my lord, specifically giving where PP was present and absent. my lord.
No, this is to be decided at the time of the hearing. We are going towards that.
My lord, whether
We are
it,
going towards that, but we have to ascertain ourselves.
my lord. We'll try to satisfy
What-
your lordship. that-
Yes, yes. No, for what purpose it has come?
My lord, on the last date, my lord, because the respondent did not appear, my lord had appointed an amicus curiae, my lord.
Where is L Devi? Oh,
Earlier occasions, she was appears.
name is not appearing.
My lord, perhaps that is why she has not appeared.
Yes, Lordship.
But otherwise, my lord, this case was fixed for hearing last year. Since now amicus curiae has been appointed, IA is also pending. My lord, may either consider the IA or fix a date for hearing, my lord.
Let her come. Name is not reflected.
Yes, Lordship.
This is a
Let
19-year-old boy, my lord. The accusation is that he eloped with a 17-year-old girl, my lord. Almost for 2 years in jail, my lord.
let the name of Miss L Devi be,
Shown in the
Reflect.
tax list.
then we can proceed.
Lordship.
As now as Learned Counsel for the Appellant, S.H. Bora, Learned Additional Public Prosecutor for the respondent number 1, State of Assam. Full stop. On the previous date of listing, comma,
10-6.
that is on 10/6/2024, comma, MSL Devi was appointed as legal aid counsel to represent the respondent number 2. Full stop. Where it is noticed that the name of L Devi Learned Legal Aid Counsel is not reflected in the cause list today. Full stop. Having considered the same, comma, the registry to reflect the name of MS L Devi as the legal aid counsel for the respondent number 2 in the cause list. Full stop. List the case immediately.
My lord, a humble prayer, my lord, date may be fixed, my lord.
You don't make relegate us to the registry.
Registry does not list, my lord. We have to
List
mention
the
everything.
case. Immediately after the ensuing summer vacation on a date to be fixed by the office.
I'm deeply obliged, my lord.
I'll go to 12 বছর আগে।
Because she did not enter appearance.
For compliance
My lord.
of that agreement, mutual
lord, my
divorce,
lord.
you have to follow the execution process.
State for the witness.
এখন তো এক্সিকিউশন কোর্টে যে বিল না হয় সুপ্রিম কোর্টে বসে এক্সিকিউশন কোর্ট আমরা হয় না এক্সিকিউটিং কোর্ট আছে না
Item number 3.
কনস্টিটিউশন কোর্ট এক্সিকিউটিং কোর্ট বানাবো হয় এটা তো আরো এটা করা নাই এটা এক্সিকিউটিং কোর্ট Yes.
My lord, steps taken.
Which no.
Alino. Yesterday.
Service
Yes.
complete. Mr. Ayush Chaudhary. On behalf of Mr. A.
Yeah,
Ahmed,
yeah.
Learned Counsel, appearing on behalf of Mr. A. Ahmed, Learned amicus curiae for the appellant, and MSB Win, Learned Senior Counsel and Additional Public Prosecutor, assisted by MS M. Chakraborty, Learned Counsel for the respondent, State of Assam. Post up. MS Win. Common Learned Additional Public Prosecutor has submitted on the basis of a report received from report dated 25/6/2020 received from the officer in charge Tinsukia Police Station. Commandant service of notice upon the respondent number 2 has been duly effected. Postal. A photocopy of the notice is placed on record. Postal. And we have the above submission command. The service of notice upon the respondent number 2 is treated to be complete. As the notice has only been served on 25/6/2024. It's a night of 25/20, yeah. Recently, and none has appeared to represent the respondent number 2. Let the case be listed immediately after the ensuing summer vacation. For appearance of the respondent number 2, it is observed that in the FOXO, in the none appears for the respondent number 2. The court might consider about appointing a legal counsel to represent the case of the respondent number 2. Will appoint
Lordship.
after this, immediately after vacation.
Obliged, Lordship.
Yes,
IA was preferred, my lord, for suspension of the sentence, my lord. It was a life sentence and compensation was awarded.
I. Objection file.
Yes, sir.
One appellant.
One appellant,
Hmm.
one accused only, my lord. Was convicted under 302, my lord.
What is a palpable apparent ground? Or what is a
My lord, I will be praying, my lord.
ex facie legal infirmity?
My lord, I will be praying, my lord, that conviction was under 302, my lord. What I say, I have gone through, my lord, 3 eyewitnesses. All the eyewitnesses have said there was an altercation between the victim and the accused prior to the incident. Because the accused was, while he was plugging betel nut from tree, it fell some of the betel nut on the tin roof of the accused and thereby caused damage. On that issue, they have some altercation, and out of that provocation, my lord, a single blow was inflicted on the accused. As a result, he expired, my lord.
Single blow, which part?
On the chest, my lord, with a sickle. Yes, my lord. He had the knowledge, but my lord, whether it was intended, my lord. My lord, 3 eyewitnesses, my lord, lordship may kindly go to.
If he has made a particular injury, knowing that in ordinary course of nature, it is likely to lead to death, knowledge or intention is not required. But if there is any altercation, sudden fight, heat of the moment, then it will come within the exception only.
Yes.
On with a sickle.
An accused is since, you know, he is behind the bar since the date of occurrence.
Oh. That is a case for hearing.
That can also be done.
Whether on the basis of entire appreciation, evidence of the entire appreciation of the entire evidence, whether this will come under exception, whether the culpable homicide of the highest degree, second degree, this will be, can be decided
Well, they-
only at the stage of final hearing, but so far here it is concerned. It is quite clear, chest,
Yes, my lord.
part of the body. Then the weapon used
Yes, my lord, she killed that.
and the death occurred almost instantaneously,
But he was taken to the hospital and then
but
he was,
prior to that reaching hospital,
yes, yes,
prior
the
to
way.
reaching hospital,
on the way. My lord, the,
and
my concern is that, my lord, the.
your
person-
313, come to your 313.
Yes,
313, page 26.
yes, my lord, he admitted.
I gave a blow on the chest of my elder brother with a sickle. What
my
more
lord.
is required? We'll close this.
My lord, the accused is
Since
behind bars since last
paper
7
is
years.
ready, we can hear it. For how,
7 years, my lord, so more than 7 years.
okay, it will be listed on priority. But so far I is concerned, I don't think. 313. Whether it will come under culpable homicide not amounting to murder, it will be after appreciation of the entire evidence. But part of the body, weapon used, the force with which it is given,
Inflicted.
and the almost instantaneous death,
These are against my lord.
exception will come.
But my lord, there was an
At the
altercation.
time of final hearing,
My lord, final here.
I
Three
don't-
eyewitnesses, 3, 5 and 9. my lord.
and your period undergone will
Yes, my lord.
come into your aid then, at that point of time, if it is culpable homicide not amounting to murder.
Yes, my lord. May I-
Heard, Mr.
I'm
Yes,
maintaining
sir.
as a legal aid counsel.
Huh? Okay, you are legal aid counsel. Yes. Heard, Mr. You might have a good case at a hearing, but not a better case in key.
So my concern is that, my lord, 7 years since the date of.
That
offence is
might
behind.
come in
Yes,
aid,
my lord,
that is what I am saying.
I understand.
T.R. Sharma, learned legal aid counsel. For the accused appellant and MS. B. Bhuya, learned senior counsel and additional public prosecutor, assisted by MS.R. Chakraborty, learned counsel for the respondent, state of Assam. To stop the instant application under section 389 1, Code of Criminal Procedure is preferred by the appellant seeking suspension of the execution of sentence passed against him and for his release on bail. Full stop. The applicant as the appellant has preferred the connected accompanying criminal appeal under section 374 2 CRPC against a judgment
Judgment dated
dated
6/7/2022.
judgment and order dated 6/7/2022 passed by the Court of Learned Additional Session Judge Golaghat, Assam, Golaghat, within bracket trial court. In sessions case number 16 of 2018, first of, by the judgment and order dated 6/7/2022, the learned trial court has found the applicant appellant guilty of the offense of murder under section 300, IPC, and he has been sentenced under section 302 IPC to undergo imprisonment for life and to pay a fine of rupees 5,000, comma, in default of payment of fine, comma, to suffer, to undergo rigorous imprisonment for further 6 months. First of para. The Mr. Sharma, learned legal aid counsel, appearing for the applicant appellant, has submitted that the petitioner has undergone petitioner is in incarceration for more than 7 years till date. First of, it is his contention that although the applicant appellant had a knowledge, but no intention could be attributed to the applicant appellant, and as such, comma, to cause murder of his elder brother, and as such, comma, the offense would not come within the scope and ambit of the offense of murder. So it is his submission that prior to the alleged act of assault, comma, there was an altercation between the applicant and the deceased. First of para. Opposing the application, comma, MS Buyal and an additional public prosecutor has contended that in considering an application for extending the benefit under section 389, comma, some of the factors which are required to be taken into consideration are the nature of weapon used, the part of the body where the injury was inflicted, the force employed in causing the injury, and the nature of death which resulted from the injury. Para. We have considered the submissions of the learned counsel by the parties and have also gone through the materials. Evidence, materials on record available in the case record of so and so, case number involved, for the purpose of considering the instant application. First of, it has emerged from the testimonies of 3 prosecution witnesses that who are they? PW,
PW1,
Three,
PW5, and
oh, 1, 3,
PW9.
5 and 9.
PW1, PW,
Sorry. 1, 3, 5 and 9.
PW3, PW,
5 and
5,
PW9.
PW9, that they had witnessed the incident of assault wherein the appellant had inflicted a blow on the chest of his elder brother, comma, Ananto Hoikia, inside the homestead of the deceased. The assault was made by a sickle.
Okay.
Full stop. The ocular testimony of the aforementioned prosecution witnesses is corroborated by the medical evidence had received sufficient corroboration from the medical evidence, which is in the form of the postmortem examination report EXT2 and the testimony of the autopsy doctor, PW.
PW2.
Two. Stop. As per the testimony of PW2, the injury was continuous page 10, intraverse incised wound extending from mid-glenoidal line full stop. As a result of it was penetrating, it was a penetrating wound which was heart deep. Full stop. Having regard to it is noticed that when the appellant was examined under section 313 CRPC, the appellant had admitted that the blow was given by him on the chest of his elder brother with a sickle. Full stop. Having regard to the nature of having regard to the nature of weapon used, the part of the body where the assault was made and the almost instantaneous death of the disease, we are of the considered view that the instant interlocutory application, the benefit by instant interlocutory application is devoid of any merit. Accordingly, the same is dismissed. Full stop. Original email appeal. Heard Mr. T.R. Sharma, learned legal aid counsel for the appellant, and M.S.B. Bhuiyan, learned senior counsel and additional public prosecutor, assisted by so and so for the respondent number 1, state of Assam. Where is the private respondent? The learned counsel for the respondent number 2 is found absent today on call. As the paper book is ready, the office to release the case. Mr. Sharma, learned legal aid counsel, has submitted that the appellant is in incarceration for more than 7 years. The officer will give obviously release the case for hearing. Seven years now. Obliged.
Item number 6.
whether the contention of the learned legal counsel that the case would come within the scope and ambit of no offense would come within the scope and ambit of culpable homicide not amounting to murder in view of exception 4. Exception 4 of section 300 IPC is required to be considered, can be considered only at the stage of final hearing of the appeal, as for considering such contention, appreciation of the entire evidence to materials on record, including the testimonies of all the prosecution witnesses, are required to be considered. Fit and fine.
May I?
Undergone surgery,
My Lord, I have received, yes, my lord, I have also the instruction that,
presently stable.
my lord, it is their version, my lord. But my instruction, my lord, I have received that his lower part, my lord, has severe. pain.
You are not professor and head department of gastroenterology.
No, I am not, my lord, but we have the instruction from the petitioner's family member, my lord. And that's why, my lord, as the instruction I have received, I have just conveyed to my lord, my lord.
What instruction?
My lord,
What instruction?
instruction is that, my lord, he is complaining of some pain in his lower part and no sensation in his.
Make the complaint before the
My-
GMC authority, jail authority.
My-
We are not the complaint box.
Lord, I am not complaining, my lord, just to inform the regarding the difficulty.
Since he is stable, we can hear the application on merit. You have filed objection.
No, Lordship, notice has not been sent.
Huh?
Lordship. We have not received the notice for the registry, Lordship.
But notice. Need proper treatment to prevent further complications. Now, whether that doctor is well equipped or doctor from some Upland Civil Hospital and the facilities therein are sufficient to prevent.
For an edge of justice, my lord. She will be referred to a better hospital nearby
Nearby is Defu Medical College Hospital.
or Nagaon.
Your Lordship, they are contemplating to
That
go
we
to
do not know
JMC.
where the facilities are available. It should be nearest also.
My lord.
Whatever facilities are available.
Your Lordship, they are contemplating to go to GMCH, Your Lordship, to by themselves, Your Lordship, and do the proper treatment, Your Lordship. Because she's not recovering, Your Lordship.
That is not a sophisticated surgery. Stone,
Yes, sir.
it is stone. I think
And-
Nagaon, Defu,
And
you have to
and
see
she-
you will be doing at the state expense also. Oh, the mayor is funny, whatever. Then jail superintendent should take
My lord.
appropriate measures
Hello.
to give proper treatment to the applicant to prevent further complication. Your letter in
My
bold,
lord.
there is a report. Heart, MS.
Your Lordship, she's suffering from some visual impairment, Your Lordship.
Huh?
Visual impairment, Your Lordship. Which I have been, the information received by me, Your Lordship. Even kidney stone and visual impairment due to diabetes, Your Lordship. So they are thinking to go to JMCH so that by themselves they can take the proper treatment. Considering the health ground, Your Lordship.
এটুকু কোট করে দেবো একটু কোট করে দেবো এটুকুই কোট করে দেবো আমি আর কেউ ঘুমাই থাকবো S. Nazneen, Learned Counsel for the applicant MSB Bhuiya, Learned Senior Counsel and Additional Public Prosecutor assisted by MS R. Chakraborty, Learned Counsel for the opposite party number 1, State of Assam. MS Bhuiya,
My lord.
the last page, medical board report.
Yes, my lord.
See the last part.
Those suggest her to refer Department of Neurology, Urology, Ophthalmology for further evaluation of suspected neuropathy, renal calculus, and visual impairment. Yeah. So, Lordship, for the angioplasty, she will be referred to GMC?
We could quote this report. We quote this report.
Yes.
We don't know what
My
kind
lord.
of this complicated medical terms,
lord.
but a panel of 4 doctors have suggested
Yes.
for referring the applicant to Department of Neurology, Urology, Ophthalmology, right?
My lord.
GMCH.
My lord.
So jail superintendent should take care of it. Last page to लिखा है medical board no. The appellant was examined by a medical board consisting of 4 doctors and constituted by the DIPHU Medical College and Hospital and DIPHU. A medical board consisting of a chairman and 3 members, doctors. After examining the appellant on 7/5/2024, the medical board submitted a report. For ready reference, the said report is extracted herein below in its entirety. So you would like last page of quote. In the subsequent period, MS Bhuiya, Learned Senior Counsel, an additional public prosecutor, has placed a medical status report of the appellant from the Superintendent Sub-Jail Haplong. As per the said communication, bearing number so and so, dated 24/6/2024, The attending doctor from Haflong Civil Hospital submitted the health status report dated 21/6/2024 in respect of the applicant, appellant. The relevant parts of the order or report are as under a bold for us, the first page of the. Full stop. A report out. Applicant appellant was admitted in the Tifu Medical College and Hospital on 15/5/2024 and was under treatment till 17/5/2024. তাৰপিছত এই মেডিকেল এক্সামিন on 7/5/2024 মেডিকেল বোর্ড from the medical board report submitted by the Tifu Medical College, from the report submitted by the medical board constituted by the Tifu Medical College and Hospital, it transpires that the applicant appellant, it transpires that medical board has suggested reference of the applicant appellant to the Department of Neurology, Department of Urology and Department of Ophthalmology, GMCH Guwahati for further evaluation of suspected neuropathy, renal calculus and visual impairment. But your application is not on this ground.
Yes, Your Lordship. Because Your Lordship,
This
while
court has
filing-
observed.
While filing the IA, Lordship, the health.
Your
conditions-
application is on merit, not on medical ground.
Filing.
We are trying to extend benefit, but there is no pleading from your
At the
side.
time of filing, Lordship, there was no such health.
Not
problem.
even an additional affidavit also is filed.
No, Your Lordship, we have filed the additional affidavit, Your Lordship. We have filed the additional affidavit, Your Lordship, mentioning the health ground, Your Lordship. It was filed on 2/5/24, Your Lordship, when we received the information regarding the health condition of the applicant, Your Lordship, appellant, Your Lordship.
Upon consideration of the above report of the medical board, report dated 75/2024 of the medical board and the health status report submitted by the dated 21/6/2024, submitted by the doctor, submitted by the medical and health officer, Haflong Civil Hospital, we direct the superintendent, Haflong Sub-Jail to make immediate necessary arrangement for getting the applicant admitted either in the nearest medical college and hospital or in the GMCH. If the recommended facilities are available or in the GMCH for undergoing treatment for the complications, medical complications suffered by the applicant. Full stop. It is observed that during this period, the appellant will be treated to be in the custody of the jail superintendent, Haflong sub-jail. Full stop. A copy of this order be furnished to MS Chakraborty Learned Counsel assisting MS Bhuiyan Learned Senior Counsel, appearing for the respondent state, respondent opposite party. Opposite party number 1, State of Assam, for taking necessary steps for her from her end. Please the case after vacation.
After vacation.
A date may be fixed, your lordship. 29
I got detail.
before,
I got detail.
before that. Oblige, your lordship. 24,
20,
oblige, your lordship.
okay, 20%.
Hey, please, your lordship, my lord, in this case, last time, my lord, they have filed the objection, my lord, but it was not brought on record. So your lordship, last order directed the registry to place it on record, my lord. So I think it has come also, it has been placed in the record, so a date may hearing of the IMA.
IA.
Yes, my lord. Actually, all the 5 ladies came before this IMA. The applicant before your lordship are all lady of the
302.
302. Of course, my lord, very pathetic, my lord. 2 person has been killed as mob lynching.
Naturally after the vacation then,
Yes, my lord.
when
Any date, lordship, as per your
My lord, let it be on 29th of
okay,
July, my lord. 30 July, sorry.
we keep it on 29.
29, actually, I'll be out, my lord. Can it be on 30, my lord? With all
31,
respect.
31.
31 will do. 30 is Tuesday, my lord, that way.
We keep this hearing matters normally.
Oh,
This is
okay.
IA.
No, take it. No issue, my lord.
Okay. Heard Mr. Jade Kamar,
31, my lord.
Senior Counsel assisted by Mr. D. Talukdar, Learned Counsel for the more than one applicants or what?
Oh, yes, my 5.
Applicants.
Total 4, sorry.
Applicants, appellants. And MS S.H. Bora, Learned Additional Public Prosecutor, opposite party number 1, State of Assam. Who's from the objection filed on behalf of the opposite party number 1, State has been brought on record. Full stop. As sought for by the Learned Counsel for the parties, lays the case on 31, 7.
Much of it.
LC received. Appeal to something. Okay. Heard Mr. Jade Kamar, Learned Senior Counsel, assisted by D. Talukdar.
No.
Appeal, and so. As the case records from the trial court have been received, the office to prepare the paper book, lays the case on 31/7/2020.
Okay.
Production list item number 1 with item 4.
Made, please, your lordship.
বাকি অর্ডার সব হয়ে গেলে
Extra copies.
মেইন ফাইল
Wait, your lordship. Lordship, this applicant here, he had suffered a stroke on 22nd of June. The lordship comes to page 21 of my IA. 21 is the type copy, 22 is the original. But it is the patient named Brojeshwar Bordoloi, son of so-and-so, has been admitted in STGH Civil Morigao since 26/24 by registration number due to cerebrovascular accident. My lord, this is his second stroke. Your lordship comes to page 16. Earlier also, he was granted interim bail because of stroke. He recovered, then he was told to surrender before the authorities and he was then jailed. Page 16 is an earlier High Court order. Paragraph 11. Today, learned counsel for the applicant has stated that he has filed an affidavit giving a report with respect to his medical examination conducted by the GMCH. Though the affidavit is not on record, he has produced photocopies of the same. On perusing the discharge certificate dated so issued by the Guwahati Medical College to the applicant, it is seen that the applicant had shown to have improved and diagnosis against him was that of cerebrovascular accident stroke. My lord, that was in 2023, August 2023. This is the second stroke that he
Which
has suffered.
paragraph you are reading?
My lord, paragraph 11, page 16, 16, paragraph 11. Today, the learned counsel for the applicant has stated that he has filed an affidavit giving a report with respect to his medical examination conducted by the Guwahati Medical College and Hospital. Though the affidavit is not in records, he has produced photocopies of the same. On perusing the discharge certificate dated 14/8/2023 issued by Guwahati Medical College and Hospital to the applicant, it is seen that the applicant had been shown to have improved and diagnosis against him was that he had cerebrovascular accident stroke. Further, it is stated that the applicant was clinically and hemodynamically stable at the time of discharge. Well, after that, he surrendered. He was in Morigaon district jail. Subsequently, again on 22nd, he has suffered 20th, he has suffered another stroke. This is the only ground, my lord. My lord, his symptoms for stroke had started on 18th. I have in page 6, paragraph 7 of my application, I have stated.
It's a report, the report of Dr. Abdul Jalil. He is not a proper format.
My
He is the doctor of Moregaon Civil Hospital.
Morigaon Civil Hospital. And last page is the actual handwritten report. We have given a type copy that is at page 21. 22 is the original report. Original.
No letterhead.
No letter item, but presently this applicant is in Morigaon Civil Hospital because he has given the seal, government doctor, his seal is there. Senior medical and health officer, SMH.
But normally such reports should be on a letterhead, official letterhead.
From different civil.
Get a report from superintendent jail tomorrow.
As it is in the page 17, it will be better, I think, for registry lordship. In
Huh?
page 17 also in earlier order lordship, Page 17, Lordship.
What?
There is also asked for a report, Lordship.
That was for earlier occasion,
So,
neurologist.
registry, Lordship.
That was in 2023.
My
So
lord,
registry, Lordship, it would be
Huh?
better. So registry, it would be better, Lordship.
Why registry? Why the state machineries are not well equipped?
So because they
Huh?
send it through WhatsApp, Lordship. Through WhatsApp.
State machinery is not well equipped.
It will be good, Lordship.
State machinery is not well equipped. You admit that?
Lordship, we will.
Huh?
Okay, I will,
Then we'll ask the
Lordship, I will.
assistance of the registry.
Lordship, I will.
They're under the state, all these medical hospitals, jail superintendent, why you involve the registry everywhere?
No.
Get the report from the jail superintendent.
hospitals,
Tomorrow,
jail superintendent or hospital, from hospital. It could be, I guess.
Morigaon Civil Hospital, superintendent. If he is currently
He's
currently lodged
he's
there.
currently there.
I will try, Lordship. Today I will send you.
Like your registration number is also given. Yes.
Friday if possible, Lordship.
Try to bring it second half, no issue tomorrow.
I will try, Lordship. A copy may be furnished, Lordship. A copy may be furnished of the order.
Copy of the application also.
Application.
Lordship.
Heard Mr. D.K. Bordasai, learned counsel for the applicant, and Mr. K.K. Das, learned additional public prosecutor for the opposite party number 1, State of Assam. First off, the instant interlocutory application under section 389 Code of Criminal Procedure, Section 1973 is referred seeking suspension of the execution of sentence passed against the applicant appellant and for his release on bail to stop. The main grounds urged in this application is that the applicant appellant is aged about more than 75 years and is undergoing incarceration for the offense under section 302 IPC. First of it is averred that the applicant appellant who is currently undergoing treatment in Morigaon Civil Hospital. But this is OPD.
My lord,
Indoor patient or outdoor patient?
presently is indoor patient.
Huh?
My first pages
Where
are
from?
OPD.
Page 19 is OPD.
OPD, madam. He had developed symptoms on 18th, then he was taken. I had mentioned in
Okay.
paragraph 7. Subsequently on
Is
20th, he was
currently undergoing treatment in Morigaon Civil Hospital. And as recently as on 20/06/2024, comma, the applicant appellant has suffered cerebrovascular accident. And because of such medical complication, comma, the doctors treating him in the Morigaon Civil Hospital has suggested treatment of the applicant appellant in the Guwahati Medical College and Hospital for further investigation and management. Para. In view of such projections, comma, Mr. Das Learned, additional public prosecutor, is to obtain a report from the jail superintendent and Morigaon jail as regards the current health status of the applicant appellant by tomorrow. You want your religion bail, you want private treatment,
My lord,
you want private treatment.
private, if possible, my lord. My lord, jail superintendent or hospital?
Oh,
Lord.
Superintendent, Morigaon Civil Hospital.
Obliged.
Tomorrow. বেলও কিন্তু স্টেট অফ হয়েই থাকে কেন নিজের আগরবার রিড দিয়ে আগরবার রিড ছিল
For hearing item number 16.
Yes,
May I please?
offense
My lord, it is under 302.
302.
My lord. And convicted for life imprisonment and fine of 5,000 rupees, my lord. Lordship,
Both.
find the FIR at page 3, my lord.
Yes,
It
FIR PS3.
My lord, it was lodged on 3/11/2002, my lord, by the son of the deceased, my lord. Page 3, I am reading the FIR, my lord. Humble submission is that around 3 p.m. yesterday, that is on 2/11/2002, all the members of our family went to jungle to bring firewood. My father was alone at home. At 4 o'clock, we returned home after collecting firewood and saw that the above named accused persons were hacking my father with a dog. On seeing us, they fled away. We brought our father to Bokadan Hospital, but he died there. I do not know as to why the accused person did so. I therefore pray to you to take necessary action after investigating into the matter and oblige me. This is the FIR, my lord. Then FIR, it names 2 persons, my lord, but during my lord trial period, one of the accused expired, my lord.
One of the
Accused expired, my lord.
expired.
My lord.
Which one?
The first one, my lord.
Okay, 4.
Binonda Kasha, my lord.
Second one.
My lord, so far as charge head is concerned, it is
Okay.
number 1. He is number 1.
SARS.
Charge head, my lord. Page 5. First one, he
When
explained.
he explained. Okay.
Then
So before framing of SARS, he suffered demise.
my lord, my,
Then how can a dead person can be
my lord,
charged?
my lord,
Thus,
my lord. Para 5 of the judgment is.
You have court in heaven also.
No, Lord.
Huh?
No, Lord.
Oh, deputy commissioner.
That is.
that's a very first.
So SARS was framed by deputy commissioner.
No, my lord, so far as,
Deputy commissioner.
yes, my lord.
Not session judge.
No. My lord, so far as judgment is concerned, page
Leave
9.
aside 34 then.
No, my lord. So far as my lord, judgment is concerned, para 5, my lord, he died on 6/3/2010. This
Para 5.
page 19, my lord.
Right. Vinanda Kocha.
Record shows the record.
SARS framing.
Charge framing, it is of 9, my lord. 8
Oh.
of 9.
Then some correction. 6/3/2010. He on date of SARS framing, he was alive.
My lord, possibly, possibly.
একটু বেশি হাতে লিখ না এই কাগজ কিনবি কাগজ কোন আমার পর গন্ডগোল হয়ে যাবে পড়াই
To super. Page 19.
স্টেশন লিখিত যাবে একটু টাইপ মারি দিছে Oh, well, I think session judge has noted it expired
My
in a red letter.
lord.
That is not the correct reflection.
Hmm.
So he died during the trial.
Oh, fine.
This is wrong.
My lord. Now prosecution, my lord. In-
So then let us go to para 5 again.
My lord. Para 5, record shows that the accused so and so died on 6/3/2010 and hence the case abated against him and that the case proceeded against the other accused.
Correct,
so-
correct.
so and so.
Correct.
During trial, my lord, prosecution examined 4 witnesses, my lord.
Hmm.
I may be permitted to read out the evidence of PW1, that
Yes.
page 8, my lord. May I read, my lord? I know the accused Sri Tofur Kujur as he lives near our village. I also know Mr. J, who is my elder brother. He is PW2, my lord.
Huh?
The name of our village,
Mr. Lee
Mr. G, my lord.
G is
PW2.
PW2 with my
The-
elder. Hmm.
The name of our village is Paharia line near Lokhijan village. We 3 brothers. The name of my other brother is Lucas G. We 3 brothers and our father lived in the same house. But my brother Mr. G and Lucas G lived together in one room. I live separately in another room. The name of our father is Lakshman G, who is no more. He was killed. The incident took place about 4 years ago. I could not remember the exact date. On the date of occurrence, myself with my wife and my brother Mr. G went to nearby forest at about 7 a.m. to collect firewood. My father Lakshmanji was alone in the house. We returned to our home in the afternoon and on our way at around 4 p.m. While we were about to reach our home, I saw 2 persons, one of whom I recognized to be the accused Tofur Kujur, assaulting my father with a dao on the village road at a distance of 20 nal from our house. When we reached the spot, assailants fled away. We saw that my father had sustained grievous injuries on different parts of his body, like face, back of his head, also got his hands fractured. Thereafter, immediately after the incident, we took our injured father to Bokajan Hospital for treatment. Next day morning at around 4 a.m., my father Lakshmanji succumbed to his injuries at Bokajan Hospital.
Thereafter, the matter was reported to Thana. Police came to hospital and held inquest over the dead body of our deceased father and prepared inquest report in our presence. Exhibit 1 is the inquest report where I put my signature. The dead body was taken to Thana. Accused Tofur Guju had himself surrendered at Buklajan PS with dao. Police seized the dao. Exhibit 2 is the seizure list where I put my signature, but the dao which is being exhibited today was not that which was deposited by accused Tofur Kujur at Bokajan PS at the time of his surrender. The dead body was taken to our home after PM examination at Dimapur. I do not know why our father was killed. Police examined me. Now cross-examination. I, along with my brother Bistar Ji and my family Sukumoni, were returning home with firewood. There is no house near the place of occurrence, but there is a plot of land on 1 and 1 Rajan Bhumis near the PO, which is situated a distance of 39 from our house. I cannot say whether sounds could be heard by other neighbors at a distance if raised from the PO. It is not a fact that I had not seen accused Tofur Kujur assaulting my father with the dao. It is also not a fact that we went to the forest at 3 p.m. It is not a fact. It is a fact that we went to the forest at 7 a.m. It is not a fact that I falsely implicated the accused Tofur Kujur in this case. Now, he is PW1 man.
In FIR, he says at 3 p.m.
Mine. The 3 p.m. That
In his evidence, he said 7
7 a.m. That is a contradiction, right? What is paramount here is the names, my lord. There, this Bistar Ji and his wife. Now PW2, my lord. I know accused, but I do not know his name. He is from our same village. Ataji is my brother. He is younger to me. We are 4 brothers, namely Lucas, Anthony, myself, and Ataji. Lakshmanji was our father. He is no more. He was killed by accused who is now on the dock. On the date of occurrence, I was not in the home. I was at Ikorarani, Bokajan. My brother were at home. While I was at Bokajan, I was informed by people of Ikorani area that my father was in serious condition and was undergoing medical treatment in Bokajan hospital. On receipt of the information, I went to Bokajan hospital in the evening. I found my father there in an unconscious state. My brother Ataje was there with my father. I could not see the injuries of my father. Police came to hospital and held inquest over the dead body of our deceased father and prepared inquest report in our presence. Exhibit 1 is the inquest report where I put my LTI. Thereafter, police took the dead body to Thana. I saw the accused in the Thana. Police told me, showing the accused, that he killed my father. Next day morning, dead body was taken to Dimapur for PM examination, cross-examination. I do not know where and when the incident took place and who were involved behind the incident. The place of Ikorani, Bokajan, where I went, is located at a distance which takes 1 hour on walking from my house of Paharia line, Lokhiganj. I resided at Ikorani. There are 5 houses nearby our house at Patharia line. I had stayed for the night at Patharia line, Lokhijan, after taking the dead body of our father after PM examination. Now he is PW2, my lord, contradicting PW1, my lord, in all aspects, my lord. Now PW3 is the post-mortem doctor, my lord. He says in his opinion that, my lord, in my opinion, cause of death is due to shock and hemorrhage due to injuries sustained by sharp object. Exhibit 3 is the post-mortem report. 3.1 is my signature. Exhibit 3.2 is the signature of Joint Director Health Service. In PM, my lord, there are 3 injuries, my lord. Page 39, Lordship may kindly see, my lord, the injuries sustained, my lord. And PW4 happens to be the second IO, my lord, who investigated the case. Because the first IO who carried out the investigation, he in the meantime expired, my lord, and could not be examined.
He said also, page 10 also.
My lord,
Also,
my lord.
incised wound over nose,
my lord, my lord. This-
incised
my lord.
wound over back of
My
the
lord.
skull, and incised wound over right side of
My
the
lord.
face. Right arm, upper arm is fractured.
My lord.
So injuries, antemortem, and caused by all three, 1, 2, 5,
My lord.
are antemortem in nature and caused by sharp object. It was due to injuries by sharp object. So death is homicidal,
My lord, that is correct.
it appears. Death is homicidal.
PW4, my lord.
It appears to be homicidal. Now, anything else?
4, my lord, is the IO, my lord. Now, here what has happened, my lord?
There also that original IO died.
My lord. The second IO, my lord, on 18/6/23, I was working as officer in charge so and so. On that day, I received a case diary of the case. Previously, SI Shahjahan Ali had investigated this case. Now he is no more. SI Shahjahan Ali had inspected the place of occurrence, had recorded the statements of witnesses and arrested the accused persons, namely so and so. And Tefur Ali so and so held the inquest over the dead body. Exhibit is the inquest report. Exhibit 1 was signature. Officer in charge Ali, I have recognized it in presence of witnesses. Shahjahan Ali had seized a dao which was used in the incident. Exhibit 4 seizure list, 4th one is the signature. And I have recognized it. After going to the case diary, I landed the PM examination report of the disease was not collected. I collected PM report. I found sufficient evidence
Myself.
against the accused persons involving their
Brother.
regarding their
Mr.
involvement
G went
and laid
to
the
the
charge.
forest at around 7 AM to collect firewood. My father, Lakshmanji, was alone in the house. We returned to our home in the afternoon. On the way, at around so and so, we were about to reach. I, along with my brother, Bistarji and my family, Sukurmani, were returning home with fire. মানে 7টা বাজে যায় 3টা 4টা বাজে আহিছে তেতিয়া দেখিছে বুলি কৈছে টফুৰ কুলু আৰু এই বিস্তাৰজি তাৰ এভিডেন্সও দি কৈছে I was not at home. I was at Ikorani Bokajan. My brothers were at home. While I was at Bokajan, I was informed by the people of Ikorani area that my father was in serious condition, was undergoing medical treatment at Bokajan. Dr. Prasad, I do not know where and when the incident took place, and who were involved behind it. Place of Ikorani is 1 hour distance. There are 5 houses nearby. The place of কোনো একজনই কৰা নাই আৰু ইহঁত দুটা ভাইক হ'লে মই সম্পূৰ্ণ পাতিলো বিনয় কৈছে মোৰ নাই ৰিলি তাত আৰু তেতিয়া নামটো দিলে কিন্তু সি কোৰ্টত আহি পেলাই কিন্তু নকলে কোৰ্টত আহি নকলে বাৰু মৰিলে সেইটো বেলেগ কথা when his evidence was recorded PW1
PW was 17th day of June 2010 my lord. Page 8
and this accused expired on
the accused expired on 10/3/2000
6/3
my lord 6/3/2010
prior to that
my lord.
I saw one of them I recognized to be accused of Furbujo. He recognized that into his business
Case number GD entry nil because seizure was made on 2/11 as per this document.
2
11, my lord, on the date of alleged incident.
2/11.
Next page 42,
What is the date of occurrence?
2/11, my lord.
Hmm?
Because third FIR was lost.
FIR,
FIR page 4,
2/11.
my lord.
FIR was lost on 3/11.
My lord, says the next day. And seizure was, or the alleged surrender was based on 2/11. Now lordship will kindly see the witnesses, my lord. This Ataje is the informant. Gathia Munda, number 2, he is not examined. The third one is also not examined. And in the charge sheet, my lord, it is mentioned that they were dispensed with.
Hmm?
In the charge sheet, there is a mention, my lord, I have seen in the paper book,
Charge sheet.
my lord. Page lordship will see. 43, my lord. Charge sheet, lordship will kindly turn to page 44.
Expired.
Page 44, Gathia dispensed. Third, 3, Pule store Udang dispensed. Now fourth is the PW2, my lord. He was not examined or examined, my lord, but seizure list was not proved through him.
Bistar, where is the seizure list again, once again?
For seizure list is with all respect.
Page
41, my lord.
41. Ataji,
He is the informant, my lord.
Gathia Munda.
My lord,
Gathia Munda dispensed.
my lord.
Then
Puleswar,
Puleswar
my lord.
dispensed.
Possibly, my lord, they would not support the prosecution that regarding surrender. That was why they were given a go by. Possibly, my lord. And in the seizure list, there is no reference of the GD entry number. My lord, if there are two sets of witnesses, one contradicting the other, my lord, lordships knows, my lord, that both are to be discarded, my lord. And so far as surrender part is concerned, my lord, thou is disputed, no, my lord, JD entry is there in the seizure list. That creates a doubt, my lord. And even if surrender is admitted, my lord, that itself cannot be a, my lord, proof of the guilt of the accused, my lord.
The DAO was not sent for serological examination.
Exactly, my lord.
That was not exhibited as material exhibit. Material exhibit? No.
No.
He was shown.
Shown, but as he did not support, my lord, possibly it was not executed as
Perhaps.
material.
And what the trial court has held, how it has been
My lord,
interpreted.
lordship will find that paragraphs, my lord, 26, 27, 28 and 34 and 35, my lord.
26,
27, 28, my lord.
28 and
Then 34 and 35, my lord.
34 and 35.
He took into consideration the surrender
Okay,
aspect,
we'll come back.
my lord. My lord.
On behalf of Amicus Curie A. Tiwari, kindly the matter be adjourned for a day.
Okay, on the affair of Ms.
D. Sharma.
D. Sharma, learned counsel, appearing from Mr. A. Tiwari, learned Amicus Curie. Please the appeal. after 3 weeks. MS Mr. K. K. Das, Learned Judicial Public Prosecutor, who is in attendance, has no objection to the said pair. A mention memo to that effect has also been circulated yesterday. So is the appeal after 3 weeks. You have a- Yes.
The relevant paragraphs, my lord,
Yes, paragraph.
dealt by the learned lower court, my lord, that lordship will find that case 27, paragraphs 26, 27, 20. Then my lord, 34 and 35. The only one who fully
Here I only wanted to state your lordship, in page 8, PW1, he has stated that he has saw the injuries, that is on lordship, face, back of his head and also hand fracture. It is corroborated with the medical report lordship, postmortem report lordship. It is also in the same places. Moreover, lordship, accused presence is not disproved lordship, he is present here. And moreover, in the FIR also lordship, he has stated, I only want to focus on one thing lordship. He has stated that he has saw the person, accused person has hacked his father with a dowel. And the same thing is reiterated in his lordship, PW8, or PW1 short lordship, in his deposition lordship. Moreover, there is no enmity is dear lordship, as far the case record is dear lordship, that the accused falsely, lordship, informant falsely implicated.
So why he has included his brother in his testimony?
Lordship,
Why he has included his brother in his testimony, that both were eyewitnesses?
Lordship. But one thing I can state here, Lordship, it is true, Lordship, there is a contradiction there.
He, brother has not supported
Yes,
PW1.
Lordship. Yes, Lordship, but one thing is there, my brother were at home. He was at home.
No, the third brother. And even
My brothers, Lordship.
they don't know how many brothers they have.
Lordship, I
Huh?
have to notice, Lordship.
PW1 says we have
Three.
3 brothers. PW4
Four,
says
Lordship.
we have
I
4 brothers.
I have to notice, Lordship.
Huh?
But the return time
And
is,
we also saw, just for our satisfaction, whether he is truthful.
Lordship, moreover, at return
In
time.
161, he said everything happened inside the home. When he came before the court, the place of occurrence changed on the road.
Lordship.
PW1 says there were no houses near the place of occurrence except Rajen Timung or something. PW2 says there are many houses.
Land only vacant land, my lord. As per PW1 vacant land.
Vacant.
And my lord, no sketch map was prepared, my lord. That is the.
No sketch map, a weapon of assault was not produced.
My lord.
Something was produced. PW denied that it is not the weapon.
Moreover, Iowa is also not there, Lordship, to question on that point, Lordship. Here's the, that, Lordship.
What was exhibited? Only
FIR and based.
inquest, postmortem,
My-
seizure.
My,
Seizure, other 2 witnesses were not there.
my,
Prosecution
No.
has not produced.
Caesar only one is the informant himself. is there.
PW1, and he denied that about the
Yes. He denied.
Dow.
He denied.
And his, except medical evidence. Medical evidence is homicidal death,
Lordship.
but because such areas
my, lord.
where he suffered injuries, nose, back of the skull, right side of the face, right upper arm fractured. It goes consistent with homicidal death by a sharp object.
Hmm.
But question is who? And when PW1 was a seizure witness to the weapon of assault on 2/11 in the police station. Next day he lost the FIR. There he named whom? This appellant and Binondo Kasa.
My, lord.
He died.
But when he came before the court, he could recognize only this accused appellant.
Lordship.
How all this can be believed? He is not supported by anybody.
Caesar list also, my lord, that GD entry is missing, my lord. Here. also.
This criminal appeal from jail under section 383, Code of Criminal Procedure 1973 is directed against a judgment, an order dated 10/12/2020, passed by the learned Sessions Judge Karbi Anglong at Difu in Sessions case number 44 of 2009, by the judgment and order dated 10/12/2020, the accused appellant has been convicted for the offense of murder and he has been sentenced under section 302, Indian Penal Code to undergo life imprisonment and to pay a fine of rupees 5,000, in default of payment of fine, to undergo a rigorous imprisonment for another year. Full stop. Para. The case was regarding the regarding alleged killing of Loxmon Z, J-E-E. Full stop. The investigation was initiated on the basis of a first information report lodged on 3/11/2002 before the officer in charge Bukajan Police Station, Karbi Anglong, by one Atta, A-T-A, Atta Z, as the informant. Full stop. In the affair, the informant, the SPW1, had inter alia stated that at around 3 p.m. on 2/12/11/2002, all the, please take your seats. All the members of their family went to the jungle to bring firewood. Full stop. At that time, his father, Laxman Ji, was alone at home. Full stop. It was at about 4 o'clock, all of them returned home after collecting firewood. Full stop. At that time, they saw the two accused persons, named in the affair, hacking his father, Laxman Ji, with a dao. Full stop. The two accused persons named in the affair were one, Tephor Kujur, that is, the accused appellant, and two, Binondo Kasa. Full stop. In the affair, the informant had further stated that on seeing them, both the accused persons fled away from the scene. Full stop. Thereafter, Laxman Z was taken to Bukajan Hospital, but he breathed his last there. Full stop. The informant further mentioned that they did not know the reason as to why the accused persons committed the act. Full stop. Para. On receipt of the FIR, the officer in charge registered the same as Bukajan Police Station, case number 138/2002, for the offense under section 302 IPC, read which 34 IPC on 3/11/2002. Full stop. It is a case of the prosecution that on 2/11/2002 itself, both the accused persons appeared in the police station, in Bukajan Police Station, with a dao, and on their such appearance, they were taken into custody, and the dao they produced was seized by a seizure list. EXT 4, in presence of 3 witnesses. 1, Ataji, that is the informant, the SPW1. 2, Gathia Munda, case 41 of the sect. And 3, Kuleswar Urang. Gathia Munda, bracketed, not a witness. Full stop run, not a witness. Full stop. The IO of the case after registration of the case, comma, the officer in charge, Bokajan Police Station. I will. The officer in charge took up officer in charge, comma, Mohammed officer in charge, comma, Shahjahan Ali. Shahjahan Ali. Officer in charge, Bokajan Police Station. PIJ, Shahjahan Ali, took up the investigation of the case. First of, during the course of investigation, comma, the IO recorded the statements of witnesses, and after conducting inquest proceeding on the dead body of the deceased, comma, forwarded the dead body for postmortem examination to the Defu Civil Hospital on 4/11/2002. Full stop. The postmortem examination on the dead body of the deceased was performed in Defu Civil Hospital on 4/11/2022 by Dr. Sudeep Ranjan De, PW4, who was posted as Senior Medical and Health Officer, comma, Defu Civil Hospital on 4/11/2002. To stop, the autopsy doctor, comma, PW4, recorded his findings in a post-mortem examination report, EXT3. Full stop. As in the meantime, comma, the investigating officer of the case, comma, Shahjahan Ali, expired comma, Mr. Sofiullah, PW4, collected the postmortem examination report, EXT4, on 30/4/2005. Full stop. As the other part of the investigation was found to be completed, comma, Mohammad Sofiullah, who was officer in charge, Bokajan Police Station at the relevant point of time, comma, submitted a charge sheet under section 173(2) CRPC against the two accused persons, comma, named in the affair, comma, finding a prima facie case established against them, provide a charge sheet number
Exhibit 5.
42/2005 on 34/2005. Stop. On in the on submission of the charge sheet, the case was committed to the Court of Sessions by an order of commitment dated 11/6/2009 in compliance of Section 209 CRPC, finding that the offense under Section 302 IPC is exclusively triable by the Court of Sessions. Full stop. On 11/6/2009, the accused person, Binanda Kasa, was produced from custody, whereas the accused appellant, Taber, accused appellant, had entered his appearance. Full stop. The copies were accordingly furnished to them, and the learned additional public prosecutor was accordingly notified. Full stop. Para. On receipt of the case records of ZR case number 376/2002, arising out of Bukajan Police Station case number 138/2002, the Court of Sessions registered the same as Sessions case number 44 of 2009. Full stop. After appearance of the two accused persons before the Court of Sessions, Karbi Anglong, Difu, within bracket, trial court for short, and after hearing the learned public prosecutor and the defense counsel, the learned trial court on Eight 10/2009 frames the following charge against the two accused persons specified. When the charge was read over and explained to the two accused persons, they claimed they abjured guilt and claimed to be tried. Full stop. During the course of the trial, the prosecution side examined 4 prosecution witnesses, VIZ, PW1, Atar Z, PW2, Bistar Z, PW3, Dr. Sudeep Ranjan De, and PW4, Muhammad Safiullah, and exhibited. Five number of documents, EIZ, EXT1, inquest report, EXT2, FIR, EXT3, postmortem examination report, EXT4, seizure list, and EXT5, charge sheet. Full stop. After closure of the prosecution witness evidence, the accused, before that, I got. During the pendency of the trial, did to Sapira Hemotal Cube. After charge of FGO trial, during the pendency of the trial, the accused person named Binanda Kacha expired on 6/3/2010. As a result, the case stood abated against him. Accordingly, the trial proceeded against the surviving accused person, comma, that is the accused appellant. Huh? During the course of the trial, huh? Para. After examined under section 313 CRPC. Full stop. When asked, the accused submitted that he would not adduce any defense evidence. Full stop. After hearing the learned counsel for the parties and after on appreciation of the evidence or materials on record, the learned trial court has convicted the accused appellant for the offense of murder under section 302, and he has been sentenced in a manner, mentioned above. We have heard Mr. N.J. Das, learned amicus curiae for the accused appellant, and Mr. K.K. Das, learned additional public prosecutor for the respondent state. Mr. Das, learned amicus curiae appearing for the appellant, has submitted that the PW1 and PW2 were the two sons of the deceased, Lakshman Z. On a comparative analysis, it is his submission that if a comparative analysis of the testimonies of PW1 and PW2 are made, some glaring inconsistencies can be found. Full stop. It is his submission that though PW1 claimed that his elder brother, PW2 was also an eyewitness to the incident of assault, PW2 did not support the version of his younger brother, PW1 by testifying that he was not an witness to the alleged incident of assault. Full stop. Mr. Das has further submitted that the appearance of the two accused persons in the police station on 2/11/2002 with the alleged weapon of assault was doubtful for the reason that the prosecution side did not examine two of the three seizure witnesses who had subscribed their signatures in the seizure list EXT code. Full stop. Though from the PME report EXT 3, the case appeared to be a homicidal death, but the evidence on record is deficient to as regards the actual assailant, real assailant real assailant of the real assailant. Full stop. In view of the glaring inconsistency in the sole testimony of the sole eyewitness, the glaring inconsistencies in the testimony of the alleged sole eyewitness makes him a wholly unreliable witness and his testimony cannot be made the basis of conviction. Full stop. With such contentions, learned amicus curiae has submitted that the accused appellant is entitled to be acquitted from the charge of murder by setting aside the impunity as been an order of the learned trial court. Full stop. In response, Mr. Das, learned additional public prosecutor, has submitted that the testimony of the eyewitness, PW1 cannot be discarded only for the reason that his version as regards presence of his elder brother, PW2 is belied by the testimony of PW2 itself. Full stop. It is his submission that on the matter of assault, the testimony of PW1 received sufficient corroboration from the medical evidence in the form of the PME report EXT so and so, and the testimony of the autopsy doctor within bracket PW3. Full stop. The fact that the two accused persons surrendered in the police station on the date of occurrence itself is a pointer towards their culpability in the crime. Full stop. He has thus submitted that the impugned judgment and order of conviction and sentence does not need any interference. Full stop. We have considered the submissions of the learned counsel for the parties and have also perused the evidence stroke materials on record, including the testimonies of the 4 prosecution witnesses available in the case record of Sessions case number
44.
Number 54, in original. Full stop. Para. It is, we first refer to the evidence, medical evidence led by the prosecution, in the form of the testimony of the autopsy doctor, Dr. Sudeep Ranjan De, who was serving as senior medical and health officer in Diffu Civil Hospital on 4/11/2002, and the PME report EXT4. Full stop. In his testimony, PW3, Dr. Sudeep Ranjan De had deposed to the fact that he conducted the postmortem examination on the dead body of the deceased on 4/11/2002. Full stop. He found during autopsy, he found an incised wound over nose, an incised wound over back of the skull, an incised wound over right side of the face, and fracture of the right upper arm. Full stop. Exhibiting the postmortem exam PME report as EXT3, he also identified the his signature therein as EXT31 and the signature of the Joint Director of Health Services, Karbi Anglong Difu, as EXT32. Full stop. The other findings recorded in the PME report, whereas under the findings recorded in the PME report, whereas under a page 10 note asen. Page 10 note 8 to 8. Para. On perusal of the PME report EXT3 and the testimony of PW3 autopsy doctor, it is found that the cause of death was due to shock and hemorrhage due to injuries sustained by a sharp object. Full stop. It can be safe, it can be held that the date of the disease, Lakshman Z was a homicidal death. Full stop. The question, arises is question, arises is who is the assailant? Question arises is about the assailant responsible for the homicidal death of the disease Lakshman Ji. Full stop. We now turn to the testimonies of the two witnesses, PW1 and PW2. Full stop. Para. PW1, Ataji. In his evidence in chief, deposed to the effect that they were three brothers namely Ataji, 1, 2 Bistarji, and 3 Lukasji. And their father was Lakshmanji. Full stop. All of them used to live in the same house. Full stop. On the incident, PW1 stated that the incident took place about 4 years earlier, but he did not remember the date. Full stop. On the date of occurrence, he, his wife, Sukurmani, and his brother, Bistarji, went to the nearby forest at around 7 p.m. to collect further firewood. Full stop. At that time, Lakshmanji was alone in the house. Full stop. PW1 further stated that when they returned to their home in the afternoon, when they were returning to their home in the afternoon, at around 4 p.m., and in the afternoon, and were about to reach their home, at around 4 p.m., they saw two persons assaulting Lakshmanji with a dao on the village road. PW1 stated to have seen the incident from a distance. No. And PW1 stated that the place of occurrence was at a distance of 20 knoll from their house. And he could recognize one of the two assailants. And the said assailant was the accused appellant. PW1 stated further that when they reached the spot, the assailants fled away. As his father, Lakshmanji, sustained grievous injuries on different parts of his body, he was taken immediately after the incident to Bukajan Hospital for treatment. But at around 4 p.m. on the following day, his father, Lakshmanji, succumbed to his injuries in Bukajan Hospital. The incident was thereafter reported to the police station, and police personnel came to the hospital and held inquests over the dead body of the deceased. After preparing an inquest report, within bracket EXT1, the dead body was sent for post-mortem examination. Dimapur ni lipo. Dimapur ko isa Dimapur ni lipo. Yera Dimapur ni ko. Post-mortem examination. PW1 further stated that the accused appellant had surrendered at Bukajan police station with a dao, and the said dao was seized by police with a seizure list within bracket EXT2, wherein he subscribed his LTI. PW1 testified that the dao which was shown to him at the time of his testimony in the court was not one which was deposited by the accused appellant at Bukajan police station at the time of his surrender. During cross-examination, PW1 reiterated that his brother, Mr. G, within bracket PW2, and his wife, Sukurmani, were with him, and all of them were returning home after collecting firewood. As regards the place of occurrence, PW1 stated that there was no house near the PO. Place of occurrence, PO, bracket, near the PO, except a plot of land belonging to one Rajen Bhumis. He denied a suggestion that he did not witness the accused appellant assaulting his father with a dowel, and that they had gone to forest at 3 p.m. only. To stop, he reiterated that all of them went to the forest at 7 a.m. Full stop. Para. PW2 Mr. G was also a son of the deceased, Lakshman G. He is also a son and is an elder brother of PW1 Ataji. Full stop. PW2 stated that he knew the accused but did not know his name. Commando, he is from the same village. Full stop. PW2 deposed that there were 4 brothers, 1 Lucas Z, 2 Anthony G, 3 Mr. G, and 4 Ataji. And the deceased Lakshman G was their father, who was killed allegedly by the accused appellant. Full stop. As regards the day of occurrence, PW2 deposed that on the day of occurrence, he was not in home and he was at Ikorani Bokajan. Full stop. PW2 stated that his brothers were at home on the day of occurrence. Full stop. PW2 testified that while he was at Bokajan, he was informed by the people of Ikorani area that his father was in serious condition and was undergoing medical treatment at Bokajan Hospital. Full stop. PW2 further stated that on receipt of the information, he went to Bokajan Hospital in the evening hours and found his father there in an unconscious state. Full stop. His younger brother, Ataji, was also there with his father. Full stop. PW2 further stated that the inquest over the dead body of the deceased was held after police personnel came to the hospital. Full stop. He exhibited the inquest report as EXT1, which is signature therein as, which is LTI therein as EXT. No, full stop. Full stop. Which is signature, which is LTI therein. Full stop. It was, according to PW2, it was police who told him, showing the accused, that he had killed, the accused had killed his father. Para, sub-para. During cross-examination, PW2 categorically stated that he did not know where and when the incident took place and who were involved behind the incident. Full stop. He stated that the place, comma, Ekorani, Ekorani, in Bokajan, where he went on the day of occurrence, comma, was located at a distance and it takes 1 hour to cover the distance on foot from their house at Paharia line, comma, Lokhijan. Because the PW2 further stated that he used to reside at Ekorani. Full stop. As regards the PO, comma, PW2 stated that there were 5 houses nearby their house at Paharia line. Full stop. Para. As mentioned here in above, comma, the mentioned here, Shahjahan Ali, who investigated into the matter first, initially, comma, expired during the pendency of the investigation, full stop. PW4, comma, Muhammad Safiullah, testified that it was Shahjahan Ali who visited the PO, comma, semicolon, recorded the statements of the witnesses, semicolon, and arrested the two accused persons, semicolon, held inquest on the dead body of the deceased, and seized the dhow, which was allegedly used in the incident. Full stop. PW4 exhibited the inquest report EXT1 and the seizure list EXT4. Full stop. PW4 recognized the signature of Shahjahan Ali appearing in the seizure list EXT4 as EXT41. Full stop. PW4 further stated that after going through the case diary, he learned that the post-PME report of the disease was not collected. And accordingly, he collected the same on 30/4/2005. Full stop. Finding sufficient evidence against the two accused persons, he stated to have laid the charge sheet against them, charge sheet within bracket EXT5. Full stop. Subpara. During cross-examination, PW4 stated that he did not see the seized dhow in the court. Full stop. Para. While it is the case of the accused appellant that there are glaring inconsistencies between the testimonies of PW1 and PW2, it is the case of the prosecution that the testimony of PW1 is received sufficient corroboration with the medical evidence, and as such, the inconsistency, alleged on behalf of the accused appellant, is not of much significance. Full stop. Para. On appreciation, on evaluation of the testimonies of PW1 1 and PW2, comma, we are not in a position to subscribe fully to the contention advanced on behalf of the prosecution. Full stop. PW1, comma, the informant son of the deceased and the younger brother of Mr. G, PW2, comma, was categorical in claiming that his elder brother, Mr. G, PW2, was with him all along the day, right from 7 a.m. in the morning till the time of occurrence on the date of occurrence. Full stop. PW1 stated that he, comma, his wife and his elder brother, comma, Mr. G, PW2, went inside the forest to collect firewood at 7 a.m. and all of them, after collecting firewood, comma, were returning together to their home in the afternoon, and when they were about to reach their home, comma, all of them saw the incident of assault made on the person of their father Lakshman G, comma, at around 4 p.m. and at a distance from 20 knots from their house. Full stop. But his such testimony did not receive support from PW2, his elder brother, comma, PW2, who testified to the effect that on the date of occurrence, comma, he was not at all in the home, comma, not to speak of accompanying his younger brother Ataji into the jungle at 7 p.m. and accompanying also at the time of returning. Full stop. PW2 had emphatically stated that his other brothers were at home on the date of occurrence, but he was in Ikorani area, Ikorani in Bukajan. Full stop. He further stated that when he was at Ikorani, comma, Bukajan, he received the information that his father was in serious condition and was undergoing medical treatment in Bukajan Hospital. Full stop. PW2 further testified that he did not know where and when the incident took place and who were involved behind the incident. Full stop. It was only the police personnel who showing him the accused, Tabor Kujur, told him that it was Tabor Kujur who had killed his father. Full stop. The testimony of PW1 as regards the place of occurrence was also belied by PW2, who stated that, unlike PW1, stated that there were 5 houses near their house. Full stop. Such testimony of PW1 is contrary to the testimony of PW2, is contrary to the testimony of PW1, who stated that there was no house near the PO, which was at a distance of 30 nol from their house. Full stop. Para. Thus, on comparative analysis, it has emerged that the versions of the 2 brothers and the 2 sons of the deceased, PW1 and PW2, were at variance. And variance is of substantial character, nature. Full stop. The contrary version of PW2 who is incidentally an elder brother of PW1, makes the testimony of PW1 out of the category of wholly reliable. Full stop. Even if it is even arguendo, the witness, PW1 is accepted as oh. Is neither wholly reliable nor wholly unreliable, then such testimony of PW1 requires appreciation with circumspection and care. Full stop. In case of a wholly reliable witness, comma, the court does not have any difficulty in coming to its conclusion either way. Thus, it may convict or may acquit on the testimony of a single witness, comma, if it is found to be above reproach or suspicion of interestedness, comma, incompetence or subornation. Full stop. If a witness is found to be wholly unreliable, comma, the court equally has no difficulty in coming to its conclusion. Full stop. It is in the third category of cases which the witness, comma, PW1 is, comma, the court has to be circumspect and has to look for corroboration in material particulars by reliable testimony, comma, direct or circumstantial. Full stop. Reverting, PW1 was found to be, is found to be a witness to the seizure list, comma, seizure list EXT1. Full stop. By the seizure list, comma, in the seizure list EXT4, comma, it was recorded that the two accused persons, VIZ, Kebor Kujur and Binondo Kasa, appeared in the police station with a dao and in reference to general diary entry, in reference to a general and by the seizure list, comma, one dao with handle was seized. Full stop. In the FIR EXT1 lodged by the informant PW1 on the subsequent day, comma, that is, comma, on 3/11/2002, comma, the informant PW1 named the two accused persons as Debor Kujur, that is the accused appellant, and Binondo Kasa. Full stop. Conspicuously, when the informant, Ataji, testified as PW1, he stated that he could recognize only the accused appellant as the assailant, and he did not name the other one of the two assailants, comma, which he named, which he saw, which he allegedly saw at the time of their appearance in the police station on 2/11/2002 and at the time of lodging, and which he named in the FIR. Full stop. This omission makes the person of the informant, that's PW1. Is a dent, is a further dent to the case of the prosecution. Full stop. The prosecution's side, for reasons best known to it, did not examine any of the other two witnesses to the seizure list EXT2. Full stop. Neither the police witness PW4 from the testimony of police witness PW4 who submitted the charge sheet. EXT5. And who had the duty to produce the alleged DAO seized by the seizure list EXT so and so, had testified, in his cross-examination, he did not see the seized DAO in the court. PW1 appeared to have shown a DAO when he was giving his deposition on 7/6/2010, and in his evidence in chief, he stated that the DAO which was exhibited, which was shown to him, was not the one which was allegedly deposited by the accused, Tabor Kujur at Bukajan police station at the time of his alleged surrender. Full stop. This, the non-examination, not exhibiting the alleged weapon of assault by the prosecution has created a further gap in its case. Full stop. Having regard to it is it is always the burden of the prosecution to prove a case beyond all reasonable doubts. Full stop. Having regard to the if the prosecution fails to prove its case beyond all reasonable doubts, the benefit at all stages, goes to the accused. Full stop. Having regard to the evidence stroke materials brought on record by the prosecution during the trial, as recapitulated above, we are of the considered view that the prosecution has not been able to bring the charge of murder against the accused appellant on the yardstick of on the standard of beyond reasonable doubts. Full stop. In such view of the matter, full stop. The learned trial court appeared to have based the order of conviction treating the testimony of PW1 as a reliable one. You bolded করে দিব আগত সোমাব লাগিব but we could not subscribe to such view because of the reasons mentioned above. এটা bolded করে দিব উপর ফিট করব লাগিব accordingly, this thus, the accused appellant is found entitled to benefit of doubt. Consequently, this criminal appeal succeeds. By an end, the judgment and order dated 10/12/2020 is accordingly set aside, and accused is acquitted of the charge of murder under section 302 IPC. First of para, the accused is to be released from detention forthwith, if his detention is not required in connection with any other case. Baki victim থাকি জান victim থাকি কিবা দিছে নেকি victim কিবা কৈছে নেকি we reiterate the recommendation made by the learned trial court as regards payment of compensation to the next of kin of the deceased as per the provision contained in section 357A CRPC. And Jurisdictional District Legal Services Authority, Karbi Anglong, is to take necessary action with regard to payment of such compensation.
Deeply honored. Problem.
Yes, what is the matter? NI? Bail.
Bail.
Yes. How long? How long you are in?
My lord, more than 500 days.
Huh?
544 days.
544 days.
First one, my lord. And two, the next one, my lord. One 544 days. Abdul Jabam, Hafizur Rahman 543 days. And Azmal Hussain, my lord, 537 days.
Make it smaller by saying 1 year, 3 months. 500 days is big. Let summer vacation be enjoyed inside the camp.
I would have no difficulty.
You do not obviously have difficulty. How big is the record? These are record.
Worship has basically to see till the stage of charge sheet.
Yes, charge sheet. How
Sir.
big is the charge sheet?
Charge sheet is-
And how big are the statements?
It's not that big.
And how many
It's not that-
statements?
Because worship, what these witnesses will be overlapping for the three appellants. The same witnesses will be there.
How many? Still
59.
89, not a small
Those
number.
are PWs.
Not PWs,
Those are PWs. Here worship 10-15 witnesses.
10.
Already taken about 6 PWs are
That is not the requirement.
eight witnesses have been examined.
That is for Article 21.
Well,
500 days is not Article 21. That will not come. Article 21. Simply on case record.
simply on the records. If
Why
there
not?
is material, then
Charge sheet. Not before vacation, after vacation.
should,
So. N. Bormon, you are for all the appellants.
no,
Mr. N. Bormon, learned counsel for the appellants, and Mr. R.K. Dev Chudri, learned deputy, standing counsel, NI.
see,
Will be what,
Deputy
DYSG,
deputy as here.
Deputy Solicitor General of India, DYSGY. Assisted by Mr. D. Bharadwaj,
Yes.
learned counsel for the respondent, NI.
103.
And Mr. K. K. Das, learned additional public prosecutor for the respondent, State of Assam, are present. Full stop. Can you, do you suggest a date since
Lordship, if it can be,
July, not immediately after vacation,
if it can be in the week commencing 29th of July,
29?
that's fine.
Okay, as sought for by the learned counsel for the party, list the appeals on 29/7.
Oblige.
Yes, what to do?
On 16.
Hope we'll be sitting in a single bench. Huh?
Division bench will be not there.
Okay. Out, list is out.
No, that's I'm saying.
Hopefully, if it is a single bench, then it will be better. Okay. P.K. Bora,
Yes, Your Lordship.
for the petitioner. B. Hugo, Standing Counsel, Finance and Taxation Department. A. Kolita, Mr. N. Kolita, Learned Counsel, appearing for Mr. A. Kolita, Learned Standing Counsel, Industry and Commerce Department, as is available now. Are present.
He's on legs in another court.
Okay, as sought for by Mr. Gogoi. Raised the case based on 16/7.
Oblige, Your Lordship.
You place the synopsis also.
Yes.
Bullet points.
Bullet point.
A. Kolita. On the request of Gogoi on 16/7.